Good afternoon. This is the Senate Judiciary Committee. It's January 25, 2023, and we have a quorum present. We have one item on our agenda this afternoon, Senate File 73, Senator Port's bill. I'll make a few opening notes here for all of us. We're going to go until our regularly scheduled time today. I am anticipating that before we adjourn for today, that I will entertain a motion to move the bill out of committee to its next stop without recommendation. And by agreement with the chief author, before the bill reaches the floor of the bill, and see it back here in Judiciary again. As those of you who've been collecting stuff in the back, this is a big bill. So there's a lot of information that we're going to have to review and vet, and we do take those responsibilities seriously, and we cannot do it in the time that was allotted prior to today or in today's hearing. So we'll circle back on that. At this point, I think what we'll do is go into the presentation from Senator Port. Then we will have counsel walk us through the bill. Then we will take public testimony or testimony for and against the bill. And then anticipating we'll have some time after that for discussion. And then we'll just take it from there. So why don't we go ahead and start? Senator Port, welcome.
Mr. Chairman. Mr. Chairman, before we begin, could I ask a process question?
Of course.
Mr. Chairman, I noticed that in the announcement for this particular meeting to hear this bill, Senate rules requires us to give the public 72 hours or 3 days notice, and in this case it was 49 hours, basically 2 days and 1 hour. And I'm a little concerned that it appears as though it's kind of a rush job. And quite honestly, we have those rules for a reason, and it's both for Senate researchers and members to keep up with the pace, but more importantly, it's for the public to have proper notice so they would have an opportunity to get a hold of their senators or maybe even seek testimony. And I simply have to raise this protest that the 3 days were not followed. And I hope that we can recognize Senate rules in the future. I know that we do have provisions that when time is of essence at the end of a legislative session, things get rather crowded, and oftentimes a 3-day notice just simply can't be required. But nevertheless, we try to do that. With 4 months remaining in this legislative session, I think we could have done better.
Senator Limmer, thank you for the reminder. We've had this colloquy in past years from different chairs at the time, but your highlight is a welcome reminder. As I say, we will be seeing this bill again, so there'll be plenty of opportunity for public input along the way. Thank you. Senator Port, let's adopt your author's amendment first, then you can discuss your bill in the shape in which you'd like it to be. Senator Umu Verbatim.
I'd like to move that author's amendment.
Senator Umu Verbatim moves the adoption of the A2 author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Port.
Thank you, Mr. Chair. Good afternoon, Mr. Chair and members. I am really pleased to be here with you to present Senate File 73, the Adult Use Cannabis Legalization Bill. I will flag that I am supposed to be in Energy Committee right now, and they are meeting right next door and have told me they will come pull me out if they need me for a vote. But I have a very able co-author who will help make sure your work is not interrupted. The prohibition of cannabis is a failed system that has not achieved the desired goals and has had incredible costs for our communities, especially for communities of color. We have an opportunity today to start the process to undo some of the harm that has been done and to create a system of regulation that works for Minnesota consumers and businesses while ensuring an opportunity in this new market for communities that have been affected by prohibition. Our main goals are to legalize, regulate, and expunge. and we are working to ensure that this bill does just that. This bill establishes an Office of Cannabis Management to oversee the regulation of cannabis and cannabis projects and transfers the medical cannabis program to the new office. It establishes a cannabis advisory council, requires studies and reports, sets up a statewide monitoring system. The bill also creates an approval process for various cannabis products, hemp-derived consumer products, establishes plant propagation standards and agricultural best practices and environmental standards. Additionally, the bill provides legal limits for adult use cannabis products, establishes 14 categories of licenses, and regulates fees and legal framework. We establish a social equity program to ensure communities most harmed by prohibition have an opportunity to engage in the industry, provide grower grants, and invest in a substance use disorder advisory council. Senate File 73 sets the tax rate for cannabis products, provides business development grant programs, sets up an automatic expungement program, as well as an expungement panel for higher level offenses, and puts in temporary regulation changes needed for the products we legalized last year. We also provide guidelines around testing, packaging, labeling, and advertising. The bill is comprehensive and will absolutely have changes over the coming months before we see it on the floor. Over the next month or so, this bill will have 18 committee stops, so you will all be as familiar with it as I am. We hope that through this process, we can work together with each other and with stakeholders to get to a final product that works best for Minnesotans. We will have many opportunities, especially on the floor, to debate the merits of legalizing cannabis, and I hope that our work in committee centers around creating the best bill with the provisions that work for Minnesota. We wanted to start this bill here in Judiciary and Public Safety Committee because we strongly believe that there can be no legalization without expungement. The harm of incarceration has been borne primarily by communities of color, especially Black men, even though in study after study, Black people use cannabis at rates roughly similar to white people. The disproportionate rates of arrest, prosecution, and incarceration in the Black community have had far-reaching effects on employment opportunities, housing, education, family stability, and wealth building, just to name a few. We have a responsibility to right this wrong and expunge all records for crimes that would now be legal under the new bill. Senator Verbaeten and I are committed to ensuring that this piece is the central tenet of this bill. Thus, we are here in front of you all first. I will pass it to my co-author to talk a little bit more about the expungement piece and then ask council to do their walkthrough. Thank you for your time and thoughtful conversation today. We look forward to working with you.
Thank you, Senator Port. Senator Verbaeten.
Thank you, Mr. Chair, members of the committee. I'd like to start by echoing Senator Port's remarks that Minnesotans are ready for us to legalize cannabis. And this bill creates a regulated marketplace that is much safer than the current underground illicit marketplace. It will allow adults to safely and responsibly use cannabis. I'd like to talk a little bit more about expungement. We know that in this bill, if we legalize cannabis, we have a responsibility to clear the records of those who were sentenced for things that will no longer be crimes. And the racial disparities on this are very clear. Black Minnesotans and white Minnesotans consume cannabis at very similar rates, yet Black Minnesotans are 5 times more likely to be arrested for possessing cannabis. This is an opportunity for us to right those wrongs. When we look at expungement, it's very important for us to be proactive as policymakers. We can't place that burden on the folks who need this. We know those folks are primarily people of color who have been impacted by this current prohibition. That burden is really on us as policymakers to initiate expungement, and that's exactly what this bill does. The bill will automatically expunge petty misdemeanor cannabis convictions, and it also establishes the Cannabis Expungement Board to review those higher charges, felonies, for expungement or for resentencing. But again, this board will get to work right away, and it is on us to initiate that action so that individuals are not, placed with another burden of asking folks to start that expungement process on their behalf. And lastly, it's just so important that the benefits of legalizing cannabis are going towards those who were harmed most by cannabis prohibition. That is why the Office of Cannabis Management will include a division of social equity. It's why this board will prioritize licenses of micro businesses and social equity applicants. Those would be folks who are residents of neighborhoods that experience disproportionately large amounts of cannabis enforcement and neighborhoods with high rates of poverty. We want them to participate in this growing industry before anyone else. This bill is an opportunity for us to repair harm, and Senator Port and I know that the Judiciary Committee in particular has very high standards, and we're committed to meeting those, to getting this right, and to getting this done. Thank you.
Thank you, Senator Umar Verbaeten. I'm just going to make a quick note. I suspect there might be a lot of people watching or participating in these proceedings that haven't seen a legislative hearing before, so I want to make sure I note that the author's amendment that was adopted earlier, that's something that we do as a matter of course and courtesy to the chief author of the bill at the first committee stop, so that the bill is in the shape that the chief author would like it to be in for our consideration. Then as the process moves on, if we adopt any other amendments, there's no such deference. We make our own decisions as members as to whether or not we want to support any changes in the proposal before us. I'm also going to note now that we're going to have the Senate Counsel walk us through the bill. Senate Counsel is a nonpartisan office that provides legal advice to all of the committee members here on both sides of the political aisle, and has done a lot of work in preparing for this particular hearing, and I will note that he's going to concentrate not only in the overall bill, but concentrate on the parts of the bill that are within the jurisdiction of the Judiciary and Public Safety and Civil Law Committee, which is this committee. So that comprises a lot of the bill, but that's what we'll be focusing our attention on. So Ken Backus, our Senate Counsel, why don't you go ahead and make your presentation. Thank you.
Thank you, Mr. Chair and members. So I guess I'll start with just a little bit of thing on the jurisdiction. The Judiciary and Public Safety Committee has jurisdiction over the threshold issue of making possession, consumption, and sale of cannabis products legal. From a criminal law perspective, the committee also has jurisdiction over the entirety of Articles 4, which is the changes to criminal penalties article, 5, which are the expungement provisions, and 8, which is the rescheduling of marijuana. In addition, the committee has jurisdiction in whole or in part over certain other criminal or public-related provisions. From a civil law perspective, the committee has jurisdiction over certain provisions related to data practices, civil penalties, and civil remedies, and I'll point these out as we go through the bill. The bulk of the bill's provisions relating to the new Office of Cannabis Management, which we can call OCM for purposes of the overview, and the office's oversight of the newly authorized legal cannabis industry, licensing, regulation, all of those things, as well as many of the bill's other provisions, are primarily within the jurisdictions of other Senate committees. There is a comprehensive section-by-section summary in your packets that was prepared by the entire Office of Senate Counsel. So in case you're interested in items that are not within the committee's jurisdiction and thus not part of this overview, or you just want a better understanding of the bill's bigger picture, you can certainly refer to that document. There's also a document in your packets that lists the provisions of the bill that are within this committee's jurisdiction. That document is entitled Senate File 73, Cannabis Legalization and Regulation, Judiciary and Public Safety Committee, January 25, 2023. You can use that to zero in on areas that interest you, and please feel free to ask questions about these areas, since this overview is meant to be essentially a big picture rather than an overly detailed one. With that, I'll begin the bill, starting with Article 1, which is entitled Regulation of Adult Use Cannabis. That begins on page 2 of the bill. This article establishes the OCM to oversee the regulation of cannabis flower, cannabis products, including lower potency cannabinoid products, and hemp-derived consumer products, and it specifies licensure categories for these businesses and requirements and procedures for licensure and operation. The bulk of this article involves the powers and duties given to the OCM to oversee this new industry, including significant number of licensing provisions, which, as I said, most of which are basically out of this committee's jurisdiction. All of these provisions in Article 1, though, are codified in a new statutory chapter of law, Chapter 342. So then, in terms of these sections that are within this committee's jurisdiction, I'll begin with Section 1 on page 2. This is the definition sections, and it defines key terms used in the bill. Section 2 on page 13 establishes the OCM and details its powers, duties, and guiding principles. The office is required to oversee the regulation of the production and sale of cannabis flower, cannabinoid products, and hemp-derived consumer products. Of note to this committee, and among a large number of other powers and duties, the office is tasked with promoting public safety, eliminating the illicit market for cannabis, preventing unauthorized access to cannabis by persons under 21 years old, overseeing the collection of fingerprints and conducting of criminal background studies on licensees and OCM employees, and imposing and collecting civil and administrative penalties. Section 3, which begins on page 16, establishes the Cannabis Advisory Council, whose membership includes some individuals with specified public safety backgrounds, among others, to review and keep abreast of specified issues relating to cannabis and to advise the OCM accordingly. Section 4, beginning on page 18, directs the OCM to conduct multiple studies and issue reports, including annual legislative reports on various issues relating to adult use cannabis, including those with certain public safety aspects. That's on page 18. Section 9, which begins on page 24, is a very important section. This is the section that provides legal limitations on the use, possession, and transportation of cannabis and cannabis products, and establishes civil penalties for violations. This section provides that a person aged 21 or older may use, possess, or transport cannabis paraphernalia, possess or transport up to 2 ounces of cannabis flower in a public place, may possess up to 5 pounds of cannabis flower in the person's residence, may possess or transport up to 8 grams of cannabis concentrate, may possess or transport edible products infused with up to 800 milligrams of THC, may give away to a person aged 21 or older cannabis flower and cannabinoid products in an amount that is legal to possess in public, may use cannabis flower and cannabinoid products in private areas, and may cultivate within one's residence up to 8 cannabis plants, of which 4 or fewer may be mature flowering ones. The section goes on to prohibit, with certain exceptions relating to the medical program, using cannabis flower or cannabinoid products if a person is under 21 years of age, or is in a place where smoking is prohibited under the Clean Air Indoor Air Act, in state correctional facilities, in public schools and related areas, and in motor vehicles. Operating a motor vehicle is prohibited under the influence of these items, as is giving these items to a person under the age of 21 years, or as promotional gifts. The section also prohibits the use of a volatile solvent to extract cannabis concentrate, and prohibits the sale of cannabis flower or cannabinoid products or the importation of hemp-derived products without an appropriate license, and then again establishes non-criminal financial penalties for violations. Section 14, which begins on page 31, provides for a national criminal history check for license applicants. Also includes a requirement that license applicants include a diagram of their premises, including a security drawing and the applicant's security plan. Beginning on page 36, section 17 gives the OCM broad powers to inspect cannabis businesses and records and permits the office to assess administrative penalties of up to $10,000 per violation. This section also addresses data issues. Section 19, beginning on page 41, provides for a national criminal history check for all licensed applicants and prospective employees. It establishes disqualifications for certain criminal offenses that last either for the person's lifetime or for 1, 5, or 10 years following discharge of sentence, but it also permits an applicant to apply for and receive a set-aside of the prohibitions relating to convictions. Section 20, which begins on page 44, requires cannabis businesses to maintain and follow security plans. And security plans are also addressed elsewhere for the licensees, but I'll just mention it here. It also prohibits businesses from sharing consumer data with federal government entities except by court order. Page 60, section 28, provides that it isn't a defense in any civil or criminal action for a cannabis wholesaler to assert that it relied on product label information or other information provided by an out-of-state manufacturer. Section 51 on page 96 authorizes patient registrants in the medical program to bring an action for damages for certain violations. Section 54 on page 100 authorizes the OCM's Division of Medical Cannabis to access all data collected in clinical trials funded by the division. Section 65 on page 120 provides that actions by a licensed cannabis business or its agents that are in compliance with the provisions of the article are considered lawful. And then the final section of that article on page 120, well, the final section for us at least, section 66 establishes a civil cause of action similar to the Dram Shop Act. Article 2, I'll skip over mostly. It's on page 121. It provides the tax structure for the retail sale of recreational cannabis under the bill. Similarly, Article 3 is entitled Business Development. It begins on page 142. I'll skip over that, but I'll note that it establishes grant programs to support cannabis businesses. Article 4 is an important article for us. It is the criminal penalties. And before I go on, I'll point out a couple of things. There are 3 documents in members' packets, and I think it's been distributed to the audience. There's a chart called marijuana sales. There's a chart called marijuana possession. Those 2 charts I prepared to give the committee and others an idea of what current penalties are for marijuana or cannabis possession and sale. There's also another chart in there. It's entitled Possession, Cultivation, and Sale and Use of Cannabis under Senate File 73 compared to current law. That is, what its title implies. It hopefully, to the degree a person or the committee wants to get into the specifics of the criminal law changes, I think those charts are intended to help you with that. Back to the overview then, sections 1 to 7 of Article 4, which is page 150 to 155, what these sections 1 to 7 do is they amend the existing 2nd through 5th degree controlled substance crimes, both sale and possession, to either remove marijuana entirely from the provision or to modify how it's treated. Sections 8 to 10 establish new penalties for the possession, sale, and cultivation of cannabis. Section 8, which begins on page 155, addresses possession and establishes petty misdemeanor, misdemeanor, gross misdemeanor, and felony crimes for possession in excess of the amounts that would be legal under the bill. It also establishes a misdemeanor penalty for using cannabis flower or cannabinoid products while driving. And it also permits local units of government to establish petty misdemeanor ordinances prohibiting the use of cannabis in public places other than those where public use is authorized in the bill. Section 9 on page 157 addresses sales of cannabis, and it also establishes petty misdemeanor, misdemeanor, gross misdemeanor, and felony crimes for selling without a license. Of note here, the upper tier penalties do require some type of aggravating factor such as sale to a minor, sale in a school or park zone, or it being a repeat offense. The section also establishes a petty misdemeanor offense for a first-time sale by a minor. Section 10, which begins on page 159, establishes gross misdemeanor and felony crimes for cultivating cannabis plants without a license and in excess of the amounts that would be legal under the bill. Sections 11 and 12 on pages 159 to 161 provide protections relating to potential revocations for individuals who are either on supervised release or probation and who lawfully use cannabis under the bill. Sections 13 and 15, page 161, 163, make conforming changes. On page 162, section 14 prohibits the administrative forfeiture of property associated with cannabis offenses. And then section 16 on page 163 directs the Commissioner of Public Safety to design and implement a 2-year pilot project to determine the efficacy of oral fluid roadside testing to determine the presence of a controlled or intoxicating substance in drivers. Before I move on, I'll just point out briefly, the A2 amendment does amend this article as well. What it does basically is it takes some of the cannabis-related definitions out of the new crimes and instead moves them to the beginning of Chapter 152, so they don't have to be repeated multiple times. It's kind of a technical change. The other change is that the first-degree possession crime is now being amended in the article, in the amendment, and it would strike the possession of 500 or more cannabis plants. The other possession threshold is left intact, but so the article amends both first and second-degree possession to strike specific references to plants. And again, plants are basically covered in the cultivation crime. Article 5 then is expungement. Sections 1 to 3 are conforming changes. That's pages 164 to 166. Section 5, which begins on page 166, provides for automatic expungement for individuals who, regarding a past cannabis case, either received a stay of adjudication under section 152.18, which is lower-level drug possession cases for basically first-time offenders, or who was convicted of a petty misdemeanor or a misdemeanor for either possessing or giving away a small amount of marijuana, or for possessing a low level of marijuana in a motor vehicle, or whose charges were dismissed prior to a probable cause determination or where proceedings were resolved in the individual's favor. Section 5 on page 168 establishes the Cannabis Expungement Board to review past charges for possession of marijuana, charges that don't qualify under Section 4, and determine whether the person committed an act that would no longer be a crime under the bill, or if the crime is a felony, that would no longer be a felony under the bill. And then to determine whether the person's conviction should be vacated, charges be dismissed, records be expunged, or whether the person should be resentenced to a lesser offense. The board's required to notify the judiciary of these determinations. Now, this doesn't apply to crimes involving dangerous weapons, bodily harm, or where elements of assault are present. It specifies the requirements of the board relating to reviews and determinations. Expungements are presumed to be in the public interest unless there is clear and convincing evidence that an expungement or resentencing to a lesser offense would create a risk to public safety. Upon receiving notification from the board that a reviewed case qualifies for an order of expungement or resentencing to a lesser offense, a court must essentially comply. The board must complete its work by June 30, 2028. Article 6 is entitled Miscellaneous Provisions. It begins on page 174. This article makes a number of conforming, albeit substantive, changes to various existing laws to accommodate the legalization decisions being made in the bill. In terms of this committee's jurisdiction, sections 1 and 2 on page 174 to 178, which authorize the governor to enter into compacts with Indian tribes regarding medical cannabis and adult use cannabis. These sections provide that acts performed pursuant to a compact are immune from civil or criminal prosecution. Sections 3 and 4 on page 178 add cross-references to the Data Practices Act, Chapter 13, for data maintained by the OCM and the Cannabis Expungement Board. Section 7 on page 180 authorizes the Department of Health to engage in research and data collection activities. Section 17 on page 184 provides exceptions to the bill's limitations on cannabis testing by providing that existing drug and alcohol testing requirements continue to apply to peace officers, firefighters, and other listed professions. Section 20 on page 189 makes conforming changes clarifying that privacy, confidentiality, and privilege provisions in the workplace drug and alcohol statute continue to apply for cannabis testing. Section 23 on page 191 prohibits the Commission of Human Services from considering a conviction for possession of marijuana that has been expunged or from considering any information relating to a record that has been expunged when determining if a person is disqualified under a background study. Section 24 on page 193 modifies the information the court administrator must periodically report to the Commissioner of Human Services. On pages 195 to 200, Sections 26, 28, 32, and 33 allow a person with a drug offense conviction to continue to be eligible for public assistance if the conviction is related to cannabis, marijuana, or THC. Sections 34 to 45 on page 200 to 207 add protections relating to cannabis possession and use for persons in the medical cannabis program or those who legally use cannabis under the bill. These are protections relating to firearm possession and use. It also provides, and this is on section 43 on page 206, that a medical program enrollee may not possess a pistol in public after medical cannabis use if the person knows that the use has the capacity to cause impairment. And then finally, for this article on page 207, there's a repealer section that, among other things, repeals section 152.027, subdivisions 3 and 4, which establish penalties for possession of low levels of marijuana in motor vehicles or for the possession or giving away for no remuneration of a small amount of marijuana. Article 7 on page 208 is entitled Temporary Regulation of Certain Products. It directs the Department of Health to temporarily regulate products containing hemp-derived cannabinoids, including products that contain CBD and edible products that contain up to 5 milligrams of THC per serving. Of note for this committee, Section 3, Subdivision 7 on page 216 provides gross misdemeanor penalties for falsifying or altering testing results or labeling information, for making false material statements to the commissioner, and for selling non-compliant products. Article 8 is entitled Scheduling of Marijuana. It begins on page 218 and continues to 239, and it moves marijuana and THC from being listed as Schedule 1 substances to being listed as Schedule 3 controlled substances. The final article is appropriations. It begins on page 239 and continues to 243. It appropriates the money for the bill. Of note for this committee, Section 1, Subdivision 3 on page 239 appropriates money for the Cannabis Expungement Board under Article 5. Subdivision 5 on page 240 reduces the appropriation to Department of Corrections. Subdivision 14 on page 242 appropriates money to the BCA. And Subdivision 18 on page 243 appropriates money to the Supreme Court. The A2 Authors Amendment essentially deleted this entire article and then reinserts it with all the appropriation and reduction amounts blank. And Mr. Chair, that's the entire article for this committee.
All right, committee members, take a breath. We've got a lot to cover today and whenever we get it back. So what we're going to do now is ask Senator Port to facilitate the presentation of some testifiers. That will be part of her presentation, and then we will go to other public testimony. We do have a list of individuals that have contacted us ahead of time that were interested in testifying. So, Senator Port.
Thank you, Chair Latz. Just to make one comment on the last piece that Mr. Bacchus spoke about, the zeroing out of all of the appropriations. That is because we do not have a fiscal note for this year yet. It is in process, and we will be getting it, and we will be back in your committee and in front of all of the other committees with the appropriate numbers in those pieces. But I wanted to let folks know that is. We didn't want to debate numbers that we knew were incorrect, so we will be back with you when we have the fiscal note for that piece. And as to testifiers, I believe Ms. Kaplan has our list just in with everyone else, so you can move through that list.
All right, thank you. So,
Thank you, Mr. Chair.
We will call to the testifier table then. Layli Fatehi from Minnesota is ready, and if Munira Muhammad from the ACLU will also come forward. We can save some transit time here as folks are getting up and returning to their seats.
And Ms. Fatehi is just an expert that will be here for me as we're moving through the questions, so she doesn't need to testify at this point.
All right. Thank you, Senator Port. Then we'll ask Joan Barron to come forward as well from Sensible Change, Minnesota. And Ms. Muhammad from the ACLU, go ahead and identify yourself for the record if you would and proceed with your testimony.
Hello, Chair Latz and members of the Judiciary Committee. My name is Munira Muhammad. I'm the Policy Associate for the ACLU of Minnesota. That would be the American Civil Liberties Union. The ACLU is in support of Senate File 73. Cannabis laws desperately need reform due to stark racial disparities in marijuana possession, and the fact that they haven't gotten better in Minnesota or nationwide. The numbers dealing with race and marijuana have been mentioned before, but still bear repeating again and again due to how egregious they are. Nationally, on average, a Black person is 3.6 times more likely to be arrested for marijuana possession than a white person, even though Black and white people equally use marijuana at similar rates. Here in Minnesota, it's an even bigger problem. A Black person is 5.4 times more likely to be arrested than a white person, which is significantly worse than the national average. The disproportionate targeting and over-policing of Black communities for substances that's equally used among the population is a logical consequence of marijuana criminalization and the byproduct of the failed war on drugs. Being caught with even the smallest amount of marijuana can risk your housing status, employment opportunities, child custody determinations, immigration status, and eligibility for financial aid. It can and does ruin lives. Senate File 73 is a viable path towards responsibly legalizing marijuana use and possession for Minnesota adults. It has strong provisions that don't simply replace marijuana prohibition with onerous fines and fees that can disproportionately affect marginalized families. It also provides clemency or resentencing for certain marijuana convictions and expungement of past marijuana convictions. We sincerely hope that the legislature takes quick and urgent action on moving this issue forward. Full legalization would stop further arrests for possession, decrease prison populations, reduce the criminalization of Black and brown communities in Minnesota and our legal system. Thank you to the chair for hearing me, and we support Senate File 73. Thank you to the members.
Thank you, Ms. Mohammed. If Angela Dawson will then come forward and take one of the seats at the testifier table, we will now hear from Joan Barron from Sensible Change Minnesota.
Okay. Hi. Thank you. Thank you for letting me speak today. My name is Joan Barron, and I am in favor of HF 100. I have currently been enrolled in our state's medical cannabis program since 2016. Since then, I've been able to get off all of my opiates, that I am free for well over a year. So that's been a huge milestone for myself. I was prescribed opiates in 2002 after a traumatic fall. I damaged and entrapped my main motor and sensory nerve of my pelvis. The pain from this condition is unspeakable pain in the most private parts of one's body. I was prescribed everything from OxyContin to fentanyl patches to eventually methadone, which I was on close to 140 milligrams a day at one point. During those early years, my then teenage son, Adam, got into those medications and moved swiftly to heroin. As I was searching for any and all treatments for my condition, going to Mayo, traveling to France 3 times for surgery and ketamine infusions, San Francisco for specialized PT, I returned to my teenage son that I didn't even recognize anymore. He was somebody I didn't know. I didn't recognize myself, and there are many years that I don't even remember. It's a damn miracle I didn't lose my life like so many of my other fellow pain warriors. They either lost their life to overdoses or suicide. I was, for all practices and purposes, impaired every time I got into a car taking those medications. There were times I'd doze off at stoplights. I could not make morning appointments because I was too groggy from the medicines that I took the night before to help me sleep. I have friends that have been fender benders on opiates and other pharmaceutical drugs. I have a dear friend that totaled her car going into a ditch because she fell asleep under those medications. For me personally, I have never been like that on cannabis. I use cannabis responsibly, the same way my husband, who, by the way, has never tried cannabis nor wants to try cannabis, indulges in alcohol, and he does it safely. There are people using cannabis right now every single day in Minnesota, regardless of the legality of it. I have 3 grandchildren, 19, 16, and 12. Our family has been completely honest with them about what Grandma takes for pain medicine. I care deeply about the safety of others on our roads and our freeways. My family paid the ultimate sacrifice for the opiate epidemic. My son lost his battle in 2014. He was 29 years old. We watched him die a slow death for 15 years, relapsing over and over again. He overdosed on the same medication that got him addicted to heroin, my opiates. I wouldn't wish that on my worst enemy. I cannot turn back the time for us as badly as I wish I could, but I can keep speaking out about harm reduction. And that's what cannabis is to me and my family. There are thousands of Minnesotans still shut out by our medical program because of the high cost. We should all have the legal right to choose a safer medication to be able to grow cannabis for ourselves or purchase in a state-regulated dispensary. I want to do that for myself, and I want that for my fellow Minnesotans. In closing, I trust the vast majority of cannabis consumers the same way I do those who consume alcohol, that they will act responsibly when behind the wheel or drive on our roads. Thank you for letting me speak today.
Thank you, Ms. Barron. I don't see Angela Dawson present or approaching the testifier table, so we'll move on. Rihanna Buckles, come on forward, please, and also Ryan Hamilton. You can come forward and take the vacant chair as well. Ms. Buckles, please state your full name for the record and go ahead.
Thank you so much, Mr. Chair and members of the committee. My name is Rihanna Buckles, and I'm the Legislative and Coalitions Director for Americans for Prosperity here in Minnesota. I am here to testify on behalf of the cannabis legalization bill and express AFP's support for the bill's passage. Americans for Prosperity believes in a dignified approach to public policy, advocating for bottom-up solutions that help every individual achieve their potential. We also believe in second chances and empowering individuals to use their experiences to make a positive impact for themselves and their community. Senate File 73 is a great example of a transformational measure that will right the long overdue wrongs of the war on drugs and uphold constitutional rights for individuals impacted far and wide by prohibition. While we enthusiastically support the expungement measures, we also believe that the bill could go farther in removing barriers for those who have past criminal records related to low-risk offenses. So, for example, we'd like to see provisions that bar large classes of individuals with various types of criminal records from the new industry be more narrowly tailored to only prohibit those who pose a unique risk in these employment and ownership roles. So such a unique risk might be someone with a criminal record that might be more likely to divert the legal cannabis products from the legal market into the gray or black markets that we do expect will still exist post-legalization for some time. We would also like to see some of the criminal penalties in the bill be changed to civil penalties. It's our opinion that these well-intended provisions should not create additional barriers in the unique situations that we face in the course of creating a new industry. It's our hope that dismantling cannabis prohibition will help reduce the number of individuals who encounter the judicial system and not be plagued by criminal records that could hinder their future opportunities. We are pleased at the progress made in this bill and look forward to supporting it on its journey through passage. This will be a monumental step forward in several aspects of our state, and we thank Senator Port for shepherding this legislation through and taking into consideration all of the various stakeholders and individuals impacted by this legislation. Thank you.
Thank you for your testimony. I'm going to ask everyone who has suggestions for how to, in their view, improve the bill, if you would just submit those in writing to our committee with just a brief itemization. And if you have page and line numbers of the bill that you can refer us to, that'd be helpful so we can kind of track what your ideas are and think about how we want to approach that as a committee. Thank you. Are you Mr. Hamilton?
Yes, sir.
Mr. Ryan Hamilton, and if Heather Backus will go ahead and approach and have a seat as well. Thank you. Go ahead, Mr. Hamilton.
Chair Latz and members of the committee, my name is Ryan Hamilton. I'm here on behalf of the Minnesota Catholic Conference, the public policy voice of the Catholic Church in Minnesota. In 2014, Pope Francis said, attempts, however limited, to legalize so-called recreational drugs are not only highly questionable from a legislative standpoint, they fail to produce the desired effects. So why aren't our predecessor states realizing the desired effects? We think the problem is that most voters who support legalization actually want decriminalization, but state legislatures are giving them commercialization. Decriminalization is defined as legislation in which an act or omission, formerly criminal, is made non-criminal and without punitive sanctions. Commercialization is defined as the process of managing or running something principally for financial gain. The commercialization of recreational drugs doesn't benefit the common good. I urge anyone who supports legalization out of a desire for racial justice to look deeper into what Senate File 27, as currently written, really is. It's a commercialization bill, with a few decriminalization provisions sprinkled in. Minnesotans should ask, what are the desired effects that we wish to gain from marijuana legalization? If reversing the harm caused by the war on drugs is the goal, then we would be wise to take notice of the effects that cannabis commercialization is having on minority communities in other states. A quick Google search revealed the following. In a 2020 report, the California Department of Justice said there is a 27% decline in felony cannabis arrests after the first year of broad legalization. That's good. That's what we want. But according to the breakdown of demographic data, Hispanics counted for nearly 42% of those arrests, while whites were at 21%. In October 2022, the Washington Post reported that 1 year after legalization, commercialization, Black adults accounted for nearly 60% of the marijuana-related cases pending in Virginia's district and circuit courts, despite Black people accounting for only 20% of that state's population. In December 2022, NPR reported that Missouri courts had to ask their state lawmakers for a supplemental budget of $2.5 million to pay overtime for 500 court clerks to go through files. This is because their felony expungement program in Missouri required a court clerk to manually pull records to see if the felony was actually for marijuana, possession of marijuana. In January 2022, the LA Times reported that when Californians voted to legalize recreational cannabis in 2016, one promise was the creation of a pathway for clearing marijuana-related convictions. But despite a 2018 law intended to speed up and automate the process, tens of thousands of Californians are still stuck with convictions on their records. The Minnesota Catholic Conference stands in solidarity with those seeking to clear their records so they can fully participate in our economy. But there's a better way to right the wrongs of prohibition than full commercialization of cannabis. And to continue to suggest otherwise is really an affront to the ideals of justice. One of the most troubling realities about Senate File 27, as currently written, is that it makes expungements, sentencing reform, and the allocation of resources to disadvantaged communities, it makes those good things contingent upon the normalization of a drug and the drug industry that has proven itself to undermine those same communities. As members of the Judiciary Committee, you are uniquely situated to reject that false dichotomy. Legalization measures that are based on commercialization have not produced the racial, social, and criminal justice outcomes that Minnesotans of goodwill are seeking. A new bill that gives marijuana decriminalization the standalone focus and attention that it deserves. If we want to be unique, let's be the first state to actually get that right. Thank you.
Thank you, Mr. Hamilton. We'll now hear from Heather Bacchus, who appears to have someone else with her as well. And while they're beginning to testify, if Colette Guyot Hempel is here, and come on forward as well. Thank you. Ms. Bacchus?
Mr. Chair, members, my name is Heather Bacchus, and this is my husband, Randy. We're here as private citizens on behalf of parents of precious youth in Minnesota that deserve better. I'm the mom of a 21-year-old son, pictured there, who died by suicide after becoming psychotic from using high-potency THC products. His habit began at 15, looking for social acceptance. Although illegal here in Minnesota, it was easily accessible. At 16, our son Randy was diagnosed with cannabis use disorder, suffering from anxiety, depression, and attended wilderness therapy. At 18, he moved to a legal use state, Colorado. Misled by an industry that profits from addiction, he believed that THC was good for him. In reality, it damaged his adolescent brain. Eventually, his use led to cannabis-induced psychosis, suicidal ideation, and completed suicide. Sadly, he took his life in July of 2021. According to NEDA,
35.7% of 12th graders have said they used marijuana. Daily use among 8th and 10th graders has increased since 2017. Research suggests that high-potency daily marijuana use may increase the chance of developing psychosis by 5 times, and those who use marijuana are 7.5 times more likely to complete suicide. Since legalization in Colorado, the number of suicides testing positive for THC has tripled more, and more youth die by suicide with THC in their system than with alcohol. 3 factors contribute to marijuana dependence: depression, anxiety, suicidal ideation, and psychosis. The age of onset of use, the frequency, and the potency. How are you going to keep high-potency products away from adolescents to keep them safe? There are more than 20,000 studies documenting the dangers of cannabis that Minnesota and the industry have decided to ignore to profit from addiction. Read medical journals, research the real dangers of this drug. This is not the weak weed you grew up with. Today's THC, cannabis, marijuana is much more potent, with levels up to 95% in THC concentrates. It's no longer just a flower, it is a designer synthetic drug backed by an industry looking to profit off addiction. It is unsafe for public. Have courage and make decisions with your heart and your mind regarding the future of our society. Stop thinking along political lines influenced by money. Our son is gone. I'm not here on his behalf. I'm here on behalf of your kids, grandkids, and our precious youth of today. Continue to decriminalize, expunge past criminal records, and educate people on the real dangers of today's marijuana, but do not legalize and commercialize this psychoactive drug. Thank you.
Thank you, Ms. Backus, and I'm sure I speak on behalf of all the committee members to express our sorrow for your loss. Thank you for your heartfelt testimony.
Good
We
afternoon.
have John Houselayden could come forward and take a chair, and Ms. Gayat-Hempel, go ahead and proceed with your testimony.
Good afternoon, Mr. Chair and Senate committee members. My name is Colette Guyot-Hempel, and I am here on behalf of Minnesota residents and live in Brooklyn Park. Thank you for allowing us to speak. I oppose legalizing marijuana and all THC products because of the harm they do. These products are linked to a number of health and criminal concerns for children and adults alike. Did you know that 1 in 6 that try marijuana before age 26 will become addicts? And 1 in 10 of the people older than 26 will be an addict. Psychotic episodes are directly linked to the usage, and those with psychotic illnesses are greatly impacted by secondhand smoke, whether it's at a concert, a park, or anywhere else. They were right. Both of the last 2 speakers were correct in the damages that this drug does. Secondhand smoke may permanently cause brain damage and birth defects and loss of IQ by as much as 8 points. That's half a standard deviation on the IQ test. And that doesn't matter what race you are. Our children are already facing an educational gap. Do they really need marijuana in their lives? Secondhand, primary, any use? Food insecurities as well as housing issues are frequent for drug users. The apartment buildings they share with other residents smell their marijuana. Other residents are affected by it going through the walls, and the THC is there. It's in the air. The National Safety Board says that 50% of all car accidents are related to drug usage. The majority of them are no longer alcohol, but marijuana and THC products. 3 kids in Clara City were on a school bus and killed by a high marijuana user that was an undocumented, illegal person. She was served found guilty, said she didn't do it, was deported, and then was back in Minnesota just a couple years after being deported. She claims she's done nothing wrong. 3 families do not have their children, and this was about a decade ago. Have we not learned that this drug is dangerous? Gun violence is frequently related to drug usage, whether it's the criminal theft to support their addiction, the domestic abuse goes up higher with those states that have legalized marijuana. Brooklyn Park Police Chief Bruley spoke after a teenager was killed by a ghost gun, saying that the majority of gun usage in Brooklyn Park is related to drugs. Think about that. This is a drug. It is a federal Schedule I drug, the same as LSD, cocaine, methamphetamines, meth, crack, ecstasy. These drugs are not safe for anyone's usage. You want to decriminalize it, that's one thing. But this drug has negative impacts on more people. I have worked for 25 years in a public school with special ed kids, and I can tell you the impulsivity, the aggressiveness of drug-related fetal alcohol and other drugs used before a child was born has a negative impact on those children for life. Parents that use drugs have a tendency to purchase the drugs over food, over housing. These kind of impacts are permanent on these kids. There is no fixing it. 5 years later, these kids have grown up in it. It impacts their ability to empower them for education and for lifelong choices. I challenge you that if you're going to pass this bill, then we need DARE programs in the middle school and the senior highs so that these kids learn that just because it's legal doesn't mean it's a good thing to do. And who are you going to try to recoup costs for the addictions? Colorado, for every $1 they get in tax money, they spend $5 to fix the problems that marijuana causes. What a waste of money. We could provide housing, we could provide broadband for across the state. We could do a whole lot better things with taxpayer dollars than support legalizing a drug that causes so much damage to families. I respectfully join the others that have said that they oppose marijuana. My heart goes out to those people that suffer because I've seen it directly in 25 years of direct service to students. This is a negative bill, and saying that we've lost the war means that we shouldn't consequence people for bad behavior is appalling. But then again, that's how some of this goes. But it is a sad state of events to think that legalizing a drug because you cannot fight it enough is the way to go. I do have some articles that support the comments that I've made that I would like to submit for future reference and for this committee to see in the future before they make a recommendation to the state. Thank you.
Thank you, ma'am, for your testimony, and we'll have a staff person get those articles from you. Thank you very much. If Kevin Torgerson and Jeff Potts will come down, you're next in line to testify. But first, we're going to hear from John Houseladen from the Minnesota Trucking Association. Go ahead, sir.
Yes, thank you, Mr. Chairman. Good afternoon, members. I am John Houseladen, President of the Minnesota Trucking Association. Legalizing recreational cannabis will make Minnesota roadways less safe, leading to more crashes, more injuries, and more fatalities. On Minnesota roadways, let's think about this. Speeds are up, law enforcement is understaffed, and there is no reliable roadside test to assess impairment. So answer, how can putting more cannabis impaired drivers on the roadway really make this situation better? You have a handout in front of you, the legalization of marijuana in Colorado, the impact dated September 21, very recent data. And I want to cite 3 statistics that show the sad truth regarding the impact of legalizing cannabis on roadway safety, and this can be found on page 2. Since recreational marijuana was legalized in 2013, traffic deaths where drivers tested positive for marijuana have increased 138%. Traffic deaths involving drivers who tested positive for marijuana have more than doubled, and the percentage of all Colorado traffic deaths involving drivers who tested positive for marijuana increased from 11% to 20%. And in speaking with the Colorado State Patrol, which I did, there is strong anecdotal evidence that marijuana impairment is underreported. So if you think about it, if a stop is made, an impairment is detected, and a blood alcohol breath sample exceeds the legal limit, the marijuana inquiry is functionally dropped. That data is never captured because you have proof of impairment and you follow down that road and don't have to do all the other things to prove that. Strong anecdotal evidence that is underreported. We think the bill is deficient in a number of other ways. The proposed roadside testing pilot uses existing technology that only indicates the presence of cannabis, not level of impairment. To truly protect Minnesotans and preserve workplace and roadway safety, we must be able to measure impairment. The bill appropriates only minimal money to the State Patrol, and this is fascinating, $0 to local law enforcement. And the dollars that are appropriated are a diversion from the Trunk Highway Fund, effectively trading fixing potholes for enforcing pot violations. Potholes for pot. And think about this, roadside law enforcement cannot identify or differentiate the difference between hemp in its raw form and marijuana in its raw form. So how does a law enforcement officer with a load determine if it is actually legal or not? And we look at, again, the report from Colorado about the black market and this myth that it drives it away. In this report, they seized 5.54 tons of marijuana, a loosely bound product. That's a lot of truckloads. Cannabis couriers and transporters are not subject to motor vehicle record checks before being qualified to transport marijuana. We think they should be. And despite the attempts to clarify what testing, discipline, and discharge employers may undertake, this bill creates fertile ground for numerous wrongful discharge lawsuits. Employers need affirmative protection against such suits when following federal and state law and their own written policies. We believe employers subject to federal DOT drug and alcohol testing, such as truck drivers, should be able to extend the same testing to all the company employees to ensure equitable treatment across the workforce. And we also believe the ongoing reporting requirements lack any meaningful tracking of workforce impacts, such as labor participation and productivity, and are really not specific enough when capturing data regarding marijuana-related highway and workplace accidents. Finally, enacting Senate File 73 into law, it will not make it legal for persons to consume cannabis and drive a commercial vehicle. However, it will raise the likelihood that persons will consume cannabis and generate a positive drug test due to confusion and misinformation. And if they have that positive result, they will be relieved of duty, and the odds of that person ever driving truck again are very low. It could exacerbate an already significant truck driver shortage. And think about this, the bill doesn't address this fact, but it will similarly impact all other DOT-regulated workforces. Airline pilots, railroad engineers, barge captains, transit drivers, all will be imperiled by legalization of this drug and its expansion. The best-crafted bill can't overcome new traffic safety and workforce risks created by legalizing cannabis, and thus we urge you to vote no on Senate File 73. Thank you.
Thank you, Mr. House-Lawton. And again, I'll ask those who have specific proposals for changes in the bill, please send those to us itemized as best you can, and identify the version of the bill that you're making reference to also, because even after today, with the author's amendment, there's going to be a first engrossment, which will change the page and line numbers for reference points. So just make sure you identify which version of the bill you're proposing to change as well. Thank you. We now have Kevin Torgerson, Olmsted County Sheriff, on behalf of the Minnesota Sheriff's Association, and Jeff Potts from Minnesota Chiefs of Police Association, the Executive Director. Go ahead and proceed with your testimony. Thank you.
Thank you, Mr. Chair and members. I am Kevin Torgerson, Olmsted County Sheriff's Office, representing the Minnesota Sheriff's Association. Most of the Senate File 73 indicates effective dates from July and August of 2023 or January of 2024. In Article 4, Section 16, this bill authorizes an oral fluid preliminary testing pilot project for public safety beginning August of 2023 until July of 2025. We ask you to give public safety the time to complete this project before full marijuana legalization. Similarly, Article 1, Section 4, lines 20.31 and to 21.10 in this bill authorizes the study and development of the effects and costs to public safety related to training more drug recognition experts, called DREs, and the retirement and replacement of current drug detection dogs. For my agency alone, that will cost us $40,000 at a minimum. It only makes sense to delay the effective dates of this bill, if passed, until public safety at all levels is adequately funded and trained to keep Minnesota safe. For nearly 20 years, we have cut the number of fatalities on our roadways nearly in half. When our states legalized marijuana, the number of traffic fatalities when other states legalized marijuana, the number of traffic fatalities have increased where one or more drivers was marijuana impaired. I'm saddened to think that the increased loss of life on our roads is considered collateral damage for those who wish to put a foreign substance in their body. We hope saving lives would be the goal of everyone in this legislature. Just recently, the Minnesota Poison Control Center noted a significant increase in ER visits of children ages 0 to 5 who had consumed THC-infused edibles. It's been stated repeatedly that marijuana is safe and it's not a gateway drug, yet treatment centers continue to advise of clients who started their addiction pathway with marijuana. The entire Article 4, Section 8 should be assessed lower weights for possession in public and the home. Today's marijuana is not your father or grandfather's marijuana that was grown in a ditch. No one needs that much marijuana in their home or on the street for personal use, and God forbid, I ask you, do you expect to prevent youth access anywhere with that much in plain view? Lastly, in Article 4, Section 9, titled 152.02 or 0264, Cannabis Sales Crimes, Subdivision 3, Sale in the Second Degree, allows for a person to possess and sell up to 2 ounces of marijuana, up to 8 grams of cannabis concentrate or edible products infused with no more than 800 milligrams of THC in a school zone, park zone, a public housing zone, or a drug treatment facility. Shouldn't these areas be zero tolerance? If we are going to do our best to prevent youth access, then no amount of drug should be allowed to be possessed and sold in these sensitive areas. Sales in a school zone should be a felony, not a gross misdemeanor. Please work with us to keep Minnesota safe, and thank you.
Thank you, Sheriff. Chief Potts.
All right, Mr. Chair, Chair Latz, and members, my name is Jeff Potts. I'm the Executive Director for the Minnesota Chiefs of Police Association, previously the police chief in the city of Bloomington. I'm here today to testify with concerns of Senate File 73 as currently drafted on behalf of the Minnesota Chiefs Association. Our association collectively represents over 300 police chiefs from across Minnesota. And Mr. Chair, understanding that the bill will come back here today for further discussion, we'll keep these comments fairly brief today, and we'll work on a letter that outlines those concerns, but look forward to another opportunity in the future. As the legislature debates the legalization of cannabis, it is important to remember that local governments and local law enforcement will be impacted by the law that ultimately passes. It is important to prioritize a tight legal market and regulatory structure to not further expand an existing illicit market. Unfortunately, this bill does not do this for a variety of reasons that are within this committee's jurisdiction. I'll just mention a couple. Number one, the significant amount of cannabis an individual can legally possess and grow in their home. This will not reinforce a tight regulatory structure through consistent retail outlets. This will create a dramatic increase in enforcement efforts by local law enforcement to address an already flourishing illicit market. Number two, the bill does not allow for the use of cannabis while operating a motor vehicle. While this is an important prohibition, it is extremely difficult to enforce as there is no commercially viable roadside test at this time. Because of the lack of a test and the complications around it, the prohibition could be strengthened with a zero tolerance policy that other states have passed and possibly prevent negative interactions with law enforcement. Mr. Chair and members of the committee, we are willing to work with the author and members of the committee to make this bill better and safer for everyone involved. We will, again, work on a letter to address those concerns, those specific concerns. And Mr. Chair and committee members, I appreciate your time here today.
Thank you, Chief Potts. Peter Coyle from the Outdoor Advertising Association, come on down, and also Alex Hassel from the League of Minnesota Cities.
Good afternoon, Mr. Chairman, members of the committee. Thank you for the opportunity to speak briefly with you today. I understand the bill is going to come back, Mr. Chairman, so I'll keep my comments brief as well. I represent the Minnesota Outdoor Advertising Association, which is comprised of approximately a dozen family-owned and national Main Street advertising companies. We're the billboard companies. We employ Minnesotans across the state, and we advertise legal products. This bill proposes a legal product and a new business opportunity for Minnesota. The outcome of that bill will be your decision to make. I want to comment specifically on Article 1, Section 58. And I've shared my comments with the author, and I appreciate the fact that she's willing to work with us on the concerns that we've identified. But very briefly, it's this. While the bill expressly authorizes a broad variety of advertising mediums to promote the availability of marijuana, assuming the product is legalized, it includes an absolute prohibition on the use of outdoor advertising. And it makes no sense to us that the legislature, should it choose to adopt the bill, would create a legal product, create a new commercial stream of commerce, if you will, but at the same time ban a form of advertising that's well accepted, maybe is used by many of you as part of your own business or political work, and we don't see any reason why the legislature would include that prohibition in the bill. Having said that, Mr. Chairman, I understand that further conversations are going to occur around the bill, and I'll withhold any further comments until that time. I appreciate the chance to speak with you today.
Thank you, Mr. Coyle. And in your future submissions, if you could identify any parallel laws with regard to alcohol and cigarettes and advertising, that'd be helpful for our analysis. Thank you.
Be happy to do that.
By the way, I will note, and we're getting toward the end of our list of testifiers, but we will allow questions from members of the committee, and so those of you who have testified, if you're able to stick around to answer any questions that members of the committee have, that would be helpful. Thanks. Ms. Hassel from the League of Minnesota Cities, and then if David Bernstein or Charles Siegel want to testify from the DWI Task Force, you can come on forward. Ms. Hassel.
Thank you, Mr. Chair and members of the committee. My name is Alex Hassel. I'm here on behalf of the League of Minnesota Cities, representing 837 cities across the state. I want to respect the jurisdiction of this committee and how this bill relates to public safety, but I do want to provide the context that our comments on these sections really connect to the larger need for a partnership between the state and cities regarding the regulation and oversight of some of these pieces. Just for some background, cities have spent considerable amount of time this past year working to put reasonable regulations in place for the THC edible products that were passed last session under a very narrow regulatory framework, with many implementing local licenses or temporary moratoriums as we seek more guidance and oversight by the state. What we have found is a significant amount of non-compliant products on the market, and really the way that it has been effectively managed is through local licensing. And I know that local licensing will be discussed in other committees, but really just want to share that it is an enforcement tool that allows local governments to respond quickly to issues that can arise from retailers. Local involvement will be critical in ensuring that cannabis and cannabis products are sold in compliance with the law. Specifically, some of the pieces under the jurisdiction of this committee, we ask that local law enforcement be authorized to conduct compliance checks, as they do with liquor and tobacco. Compliance checks statewide will be a huge task for this new board, and to make sure that these checks happen, it is important to include local governments in that process. These checks are an important tool to ensure that retailers are acting in accordance with the law and not selling to those who are under the legal age. While certainly not all retailers are bad actors, some unfortunately do fail to maintain compliance. This history allows licensing authorities to ensure that they provide licenses to responsible retailers that do not have a history of noncompliance. Additionally, under this bill, all inspections would be handled by the state, and if public safety issues arise locally, it creates a response timeline of 30 days for the state to complete any necessary inspections. We're glad to see that the state will be taking an active role in enforcement, but 30 days is far too long for local communities to have to wait for the state to have capacity to enforce the regulations. We ask that cities share in some of this responsibility by authorizing those local compliance checks. This is just one example of where local governments fit into this discussion, and as you've heard from local law enforcement as well, there are significant impacts to public safety and the time and resources for law enforcement that they will have to spend on this issue, which we hope the committee considers. I will leave it at that, but I thank you for your time, and I appreciate Senator Port and her willingness to work with us on this legislation. Thank you.
Thank you, Ms. Hassel. David Bernstein from the Minnesota DWI Task Force, and if Oliver Steinberg will come on down in preparation for your testimony as well. Thank you. Mr. Bernstein.
Thank you, Chair Latz, members of the committee. My name is David Bernstein, and I'm the chair of Minnesota's DWI Task Force. For those who are unfamiliar, we are a volunteer organization. We are nonprofit, unfunded, unaffiliated. Our goal is to eliminate impaired driving on Minnesota's roadways. We have a big diversity of perspectives from individuals across the criminal justice system. The DWI Task Force is not taking a position on the cannabis legalization bill, Senate File 73, which is much broader in scope and beyond our purview. But there are some important highway safety considerations that need to be addressed in this bill. And we have drafted proposals. We've met with Senator Latz. We've also met with Representative Stevenson in the House. And I welcome Senator Port's invitation to meet as well to discuss some of these. I do want to emphasize a lot of this bill addresses use and possession, which is not what the DWI Task Force is addressing. We are addressing impaired driving. And that is a concern when it comes to marijuana use. There are plenty of studies which support that marijuana has the capacity to impair a person's ability to operate a motor vehicle, not only independently, but also in conjunction with other substances such as alcohol or even prescription drugs. Alcohol is a legal substance, but it is still illegal to drive under the influence or impaired. And the DWI Task Force's goal is to align DWI marijuana laws with the DWI alcohol laws. Part of that, it will be important to educate the public. There was a study released by AAA in December of 2022, just last month, which indicated that 94% of drivers believe that driving after drinking enough alcohol to be over the limit to be very dangerous. Only 65% believe that driving within 1 hour of using marijuana is dangerous. That's very concerning. 5% actually admitted to doing it within the past month. And while 5% is a low number, there are likely many more than actually admitted it. And any number higher than 0 is concerning. And so it will be important to educate the public and to do so through policies. One way that this committee can do so is with consistency in terms and its messaging. So for example, looking at Senate File 73, there are many places where the term cannabis is used. There are other places, such as the Scheduled Controlled Substances, where the term marijuana is used. That's going to create confusion amongst the public, but more importantly, that also creates ambiguous legal standards. And so it will be important for the legislature, if Senate File 73 is to pass, to consider a consistent term and for all the legal standards to be tailored and authored appropriately. The task force, as I mentioned, has drafted some proposals. They are in writing. I'd be happy to meet with anyone who would like to discuss these further, and I look forward to hopefully meeting with Senator Port. But just to briefly outline again, the goal is to align DWI marijuana laws. So for example, a prohibition on underage use and driving, similar to the underage drinking and driving. Minnesota currently has an open bottle law, where if you have alcohol, it either needs to be unopened or kept in the trunk or trunk-like area. And the task force is proposing a consistent provision with respect to cannabis or marijuana. It's good public policy to make sure that if you transport marijuana, it should be kept unopened or in the trunk in order to avoid the potential of impaired driving. It's also important to note that it's not a defense if impairment is derived from hemp, edible cannabinoid products, or medical cannabis. Impairment is impairment, and that's what we're focused on when it comes to public safety and highway safety. So again, the DWI task force is not looking at criminalizing use, but we are looking at the focus on impaired driving and making sure we keep highways safe. Again, I'm happy to meet with anyone to discuss the proposals and send the written proposals to you, and I look forward to additional conversations. Thank you.
Thank you, Mr. Bernstein. Oliver Steinberg.
Thank you, Chairman Latz, members. My name is Oliver Steinberg. I'm a resident of St. Paul. I am a member of and leader of some of the drug reform activity in this state, but I'm speaking today only on my own behalf as a citizen, taxpayer, and parent. And I thank you for the opportunity. Now, there's 3 reasons why I am encouraged by Senate File 73, because it's past time to end the cannabis prohibition. And there are 3 compelling reasons that your committee should consider. First is to rectify longstanding corrosive injustice. Second is to enhance and improve public safety. And third is to restore respect for more worthy laws and for the institutions that our society depends on for civic order and liberty under law. Now, the anti-legalization zealots are trying to deflect the debate or confuse it with the alleged hazards to health and public safety attributed by them to cannabis consumption. And I respect that and their point of view. But it's not just science we have to learn from, but also history. And what we've got to realize is that our approach to the use of this substance and others has not worked. And there's a far greater harm to public health and civic safety from the law than from the leaf. We've got to remember the unintended consequences of alcohol prohibition, the violent clandestine markets, criminal gangs, corruption, contaminated products, overcrowded courts and prisons, Titanic-sized tax evasion, and cynical disrespect for laws in general. And the war on drugs is repeating that folly. The anti-cannabis legislation was overtly racist in its origins, and it's been indisputably discriminatory as implemented. It forms the keystone of the so-called New Jim Crow, ostensibly a colorblind law that perpetuates historic patterns of racial caste oppression. So we've tried for decades draconian laws, saturation anti-drug propaganda, mass incarceration, high-tech surveillance, police state paranoia, and we've succeeded perhaps in terrorizing or intimidating citizens, in canceling civil liberties, in blighting both urban and rural communities without eradicating the outlawed substance. Prohibition fails, even on its own terms. And what about public safety? During the Al Capone bootlegging era, 20,000 lives were rubbed out in just 14 years. After alcohol prohibition was repealed in 1933, for 10 consecutive years, the rate of murders and assaults by firearms in this country declined until about half the original level. And that is the reason so compelling that you must tackle this problem of ending cannabis prohibition. I will distribute for your committee a page full of news items from our state of young people mostly getting killed because they're trying to buy or sell cannabis in the illicit marketplace. And that's one of the charges of this bill, is to curtail the illicit market, to put the gangs out of business, make our youth safe. Indeed, there are risks and dangers associated with cannabis consumption, and education is essential. I advocate it. But there's a whole lot quicker and more destructive damage to a young person's brain from a bullet than from a blunt. So let's put the gangs out of business by taking the business out of the gangs. Curtailing the illicit market depends on this. You've got to provide legal products as low in price and as high in quality as the unregulated market can supply. That means don't impose excessive regulations driving up unnecessarily business overhead costs. Don't permit corporate concentration to monopolize a market and charge artificially inflated prices. And the best way to ensure against this is done in Senate File 73, and that is allowing a home grow option. And finally, don't overtax the industry. Those rules will, when we finally end federal prohibition, really put a crimp in the black market and make all of us safer. So, in conclusion, I would say that the bill could be improved. There are many parts of it that are sort of like a Rube Goldberg cartoon in the complications of how they impose regulations. The entire licensing scheme seems to me to violate Article 13, Section 7 of the Minnesota Constitution, which says that any person may sell or peddle the product of a farm or garden occupied and cultivated by him without obtaining a license, therefore. Very plain English. And apparently this bill doesn't take that into account. I think it should. Then ultimately, over the past 10 years, the people of 14 states have voted to end cannabis prohibition. The legislatures of another 7 states have decided to take this step. 4 territories, including the District of Columbia, also have ended prohibition. This is what the American people want. This is notable. None of those jurisdictions have reversed that decision or rescinded their law. They don't go back because legalization, which isn't perfect, works. And we need to learn that lesson. And I encourage you to consider, study, and adopt a bill along the lines such as proposed here. Thank you.
Thank you, Mr. Steinberg. We did receive a note from one other person that sought to testify, and I'll give a few minutes also if there's anyone else that wishes to add a few remarks. I want to leave some time here for the committee members to ask questions as well. So is Thomas Evanstead present? Mr. Evanstead, come on down. Go ahead and state your name for the record.
Thank you.
Testimony.
Good afternoon, Chair Latz, Senator Port. I want to thank also Rep. Stevenson
regarding this bill, the legalization of recreational cannabis in Minnesota. My name is Thomas Evenstad, Evenstad, and I'm with Public Safety Minnesota, and I testify today in very much support of this bill. On September 6, 1988, U.S. Administrative Law Judge Francis Young declared, quote, marijuana in its natural form is one of the safest therapeutic substances known to man, unquote. No human in 5,000 years of consuming cannabis has fatally overdosed. It is impossible to consume enough cannabis to kill even the lab rats, the animals that they've tested to try to determine cannabis's lethality. The empirical evidence from rec legal states citing NORML's research, all verifiable, is that the highways and the roads are not more dangerous post-legalization, but rather it's the opposite. They're safer. Most experts, including myself, attribute the reduction in DUI-related deaths to increased cannabis and reduced alcohol consumption for drivers on the roads in states that have legalized cannabis. Many recreational cannabis users like myself choose to consume cannabis instead of alcohol after experiencing the damage that alcohol causes as opposed to the health benefits of cannabis. I lost my own nephew, 25-year-old Matthew Thomas Campagnoni, to a drunk driver he was trying to save. I urge the bill's authors to add the Illinois provision prohibiting law enforcement from using the I smell weed ruse that allows them to toss anyone's vehicle, whether they actually do smell weed or not, for the confiscation and the seizure gravy train that they've enjoyed forever and they are fighting so hard to keep. This bill will not address racial disparity or profiling, racial profiling without it. SB 2939 is the legislation amending the Illinois Vehicle Code. And then personally, I want to say that 40 years ago, at age 17, I was made a cannabis criminal by the state of Minnesota. I will never forget having to be in the Hennepin County Courthouse with my parents and dealing with the prosecutors of the state. And I do remember the name of the judge, Pamela Alexander, African-American judge, and I had a 152-18 40 years ago. So I'm greatly looking forward to having that expunged. And I want to briefly touch on prohibition. The reason that we're here is because cannabis is illegal. One of the testifiers talked about cannabis, marijuana, the terms. I urge the committee to use cannabis solely because marijuana is a racist term. If you look at the history, I implore everybody involved in this bill to read The Emperor Wears No Clothes by Jack Herer, H-E-R-E-R, widely considered the most knowledgeable person about cannabis in the world and ever. In 1937, Henry Anslinger, who was the U.S. drug czar, this is critically important because it touches right here in Minnesota. And again, I'll be brief and I thank you, Chair. Anslinger testified before Congress saying, quote, marijuana is the most violence-causing drug in the history of mankind, unquote. This, along with Anslinger's outrageous racist statements and beliefs, was made to the Southern-dominated Congressional Committee and is now an embarrassment to read in its entirety. For example, Anslinger kept a Gore file, culled almost entirely from Hearst, the magnet Hearst with the publications, and other sensational tabloids, e.g. stories of axe murders where one of the participants reportedly smoked a joint 4 days before committing the crime. Anslinger pushed on Congress as a factual statement that about 50% of all violent crimes committed in the United States were committed by Spaniards, Mexican Americans, Latinos, Filipinos, African Americans, and Greeks, and that these crimes could be traced directly back to marijuana. Not one of Anslinger marijuana Gore files of the 30s is believed to be true by scholars who have painstakingly checked the facts. In fact, FBI statistics, had Anslinger bothered to check, showed that at least 65 to 75% of all murders in the U.S. were then, and they still are, alcohol-related. Alcohol is legal. As an example of his racist statements, Anslinger read into the U.S. Congressional Record testimony without objection stories about coloreds, quote unquote, with big lips, luring white women with jazz music and marijuana. He read an account of 2 black students at the University of Minnesota doing this to a white co-ed, quote, with the result of pregnancy, unquote. The congressmen of 1937 gasped at this and the fact that this drug seemingly caused white women to touch or even look at a quote-unquote Negro. And I'll finish with this. Virtually no one in America, other than a handful of rich industrialists and their hired cops, knew that the chief potential competitor, hemp, was being outlawed under the name marijuana. That's right. Marijuana was most likely just a pretext for hemp prohibition and economic suppression. So I urge the committee, when you look at the history, if you study the racist history of cannabis prohibition and the use of the term marijuana, it comes right back to our own University of Minnesota. And finally, my sister was this gateway argument that we hear about. Cannabis can be a gateway. And the reason it would be a gateway is because people have to go to the black market, to criminals by definition, to obtain cannabis. At 16 in Edina, 45 years ago, my only sister went to obtain some cannabis, a joint. She wound up being raped and pimped from New York to Los Angeles because the gateway was the gangs that have the harder drugs that strung her out and they human trafficked her from coast to coast. So I do challenge Senator Limmer today, who I've emailed repeatedly and called repeatedly to your office, and you have never responded to my overtures to actually get a public safety bill that works. MSOP for violent criminals, the Minnesota Violent Offender Program. Thank you, everybody, and God bless.
Thank you, Mr. Evanstead. We're going to go until 2:45 today, and we do have to make sure we're out of the room by then for the next committee that will be coming in. I want to leave some time for committee members to ask questions as well. Before I do that, is there anyone else in the audience that would like to make some brief remarks relating to this case? Yes, come on forward, please. Go ahead and
Hi.
tell us your name and
My
proceed.
name is Bridget Pinder. I am a hemp farmer and cannabis company owner here in Minnesota. We've been farming since 2018. We have 18 acres west in a rural area. This year we got to invite the local sheriffs from Stearns County out to our farm because they had some questions about how do we tell the difference between hemp and cannabis. And so it was a really fun interaction that we got to have with the sheriffs, educating them about that you really can't tell the difference, as we've heard. And the other thing that I got to talk to with them about was the roadside impairment that we hear a lot about. And my question to them was, how do we test for opioids? How do we test for opioid impairment? There's no test for you to blow into or anything like that, like there is for alcohol, to test for opioids. So we talked about, how they do their roadside testing and of people that are impaired from anything, from sleep deprivation, from opioids, from things like that, so that as a cannabis community, we're putting it out there that would be the same type of test that they would do for cannabis impairment, since cannabis stays in our system for up to 30 days. So it's nice that farmers like us and people in the cannabis industry can have cooperation with the sheriffs and things like that in our areas. So I just wanted to touch on that a little bit. Thank you.
Thank you very much. Appreciate it. Is there anyone else who wants to come forward and make some remarks at this time? I don't see anyone else in the audience, so thank you for all of the public testimony. Let's open it up now to the members of the committee. If there are any questions for the chief author, Senator Port, who's coming forward, or anyone else who testified, or other comments. Senator Limmer.
Thank you, Mr. Chairman. Since we're just at the tail end of testifiers, I did want to raise an issue that Min Koji brought up regarding certain data practice issues in the current bill. And I see that Mr. Matt Elling is here. I have an amendment, but I am not going to introduce it today. This is more a gathering of information and better to understand the bill. But I would like to have Mr. Ealing just give a very, very brief description of their concerns regarding certain data practice issues that they've raised.
Sure. Is Matt Ailing here? Come on forward, if you would, give us a few minutes of your perspective. And I think we've received some information also here in the committee as well. So go ahead.
Thank you, Chair Latz. My name is Matt Ealing. I'm with the Minnesota Coalition on government information. Thank you, Senators and Senator Port. We've submitted information to yourself as well. First of all, I just want to say we've been working on this since HF 100 was introduced in the House. We've worked with Representative Stevenson, who took a couple of our amendments. Representative Scott, rather, also brought forward an amendment that was adopted, and those are in the A2 amendment that was adopted by this committee. So we'd like to thank everybody that's worked on this, and it's been a bipartisan work on the data provision so far. So thanks for that. The remaining work that we see came out of discussions in House Judiciary. So there's data regarding applicants that is, for the most part, classified as not public at the applicant stage, and that follows the standard state licensing framework in 1341. We feel that's not a good fit for the kind of business that's being regulated here, because the 1341 framework is more about individual license holders, police officers, attorneys, et cetera. And we feel this should be more similar to point-of-sale licensing for alcohol in terms of how the applicant data is treated. And most of that is done at the local level, where the application data is almost all public. So if there's a bar moving into your community, you can find out at the application stage who owns it, basically what their business plans are, et cetera. But you wouldn't be able to do that in the cannabis point-of-sale context. So I think there's more work to be done there, as well as trying to figure out clarity around some of the data that the government entity that regulates these businesses conducts, such as the data in regard to scoring of the applicants. So, and it's a big bill, so I'm sure there's other data issues that are out there, but those are two that we've highlighted, and we're certainly willing to work with folks going forward.
Thank you, Mr. Ealing, for your testimony.
Mr. Chair, if I may.
Senator Port.
Senator Limmer, thank you for bringing this up. This is an important piece of the work that we're doing on this bill, and if you'd like to have conversations about your amendment, we're still in conversations with Minnesota COGI. This is a piece we want to get right, so I appreciate your willingness to work on it.
Thank you. Any follow-up with Mr. Ealing on this topic? All right. Thank you. Senator Port, I have a question for you. Sure. This would be legalizing a smokable form of marijuana for general use, and there's some of us in the legislature that were very active in the clean indoor air and other cigarette-related use relating to secondhand smoke impacts. Can you give some idea how this bill approaches that, and whether the public health folks involved in those efforts were involved in the formulation of this bill?
Absolutely. Thank you for the question, Chair Latz. This is something we take pretty seriously in this bill, and the Indoor Clean Air Act still applies to every aspect of this bill. Because marijuana is being legalized does not mean that you can smoke it in places where we currently prohibit smoking, and the work that we've done, important work we've done on the Indoor Clean Air Act. Local governments can also prohibit smoking and vaping just like they can currently. So that's another aspect of it. The one exception, I will say, the provisions that pertain to licensing for on-site consumption do not allow for smoking in those places. The one exception being for cannabis event licensing, which does have a provision that allows for the license to include smoking. But essentially all of the other provisions of the Indoor Clean Air Act are intact. We also have provisions in this bill to do education, particularly to young people, that will continue to talk about the harms of marijuana.
Just to clarify on that point.
Go ahead, please state your name so we have it for the public record.
My apologies. My name is Layli Fadahi. I'm the campaign manager for MN is Ready. We are the largest and most diverse coalition of cannabis policy stakeholders in the state, and we've been working to ensure that Minnesota not just legalizes adult use cannabis, but has a legalization framework that prioritizes safety, equity, and Minnesota first approach to the industry. Just wanted to provide the clarification to what Senator Port was saying about that exception with the cannabis event licensing. So what that provision allows is for local governments, should they choose to smokable and vapable forms of consumption to be allowed at such an event, but as long as it is in a designated area for smoking and vaping, and it has to not be visible from any public place. And in instances where that is allowed, tobacco and alcohol must be prohibited.
So thank you. And one of the reasons I asked the question is that the studies are starting to be more evident. You know, for many years there was a prohibition, federal prohibition on even studying marijuana, researching it. But the information that I'm receiving is that marijuana secondhand smoke has 3 to 5 times more particulate matter in the secondhand smoke than regular cigarettes do. Clearly, there's a psychoactive component to the smoke which is not present in tobacco cigarettes. And the harm to youth in particular in developing brains, from the information I'm gathering, is more concerning than for regular cigarettes. Is there anything special about this bill that would provide added protections under those circumstances, particularly for youth? I also know people who live in multifamily housing where even cigarette smoke is a bother. Marijuana smoke can be even more pervasive and seems to be able to infiltrate more of the public and even private spaces in multifamily housing as well. So how does this bill approach that, if it does specifically?
All right, so as Senator Port was saying, the Indoor Clean Air Act would still apply in all of these instances. It does not eliminate the kind of nuisance type restrictions that are often, apply in different housing situations. It prohibits the product from being utilized in, say, a vehicle in the way, tobacco often will be. And there is a prohibition in the bill on flavored smokable and vapable products, since those are often targeted towards children. So in the drafting of the bill, there's been attention to not trying to make this more permissible in any way than would be the case for tobacco.
Was the public health community involved in any way in the drafting of this bill? Those who were involved in the Smoke-Free Coalition, for example, secondhand smoke folks?
That I don't know, Mr. Chair. I believe that these provisions of the bill were developed by staff. I'd be happy to inquire as to what that consultation looked like. But in general, the drafting of this bill has been put together with enormous volumes of research drawn across all of the other states that have legalization policy, and it's had pretty multidisciplinary involvement. But I'd be happy to find out specifically about the involvement of public health officials or professionals with knowledge of smoking.
Thank you. I would appreciate that. And if you could share with me any information you have on what other states have done specifically with regard to the ancillary impact of this use on youth and bystanders as well, that would be helpful. And I know the states where this was approved by referendum, there are probably very few guardrails in the referenda language, but where there was legislative action, there might be some more or something subsequent. Senator Port?
Yeah, thank you, Mr. Chair. Just to also flag, after you raised this concern with me earlier today, I did send an email reaching out to a couple of those groups to ask for their insights on the bill and ways that we can strengthen and especially ensure for young children that they have the least impact possible from secondhand smoke.
Thank you. I know this, I don't think I'm the only one who's having some thoughts along these lines. You can walk into some apartment buildings or condo buildings, and if there's one person in one unit that's smoking marijuana, you can smell it all the way down the halls. It seems to be a little more permeating than regular cigarette smoke as well. And so it might be worth taking a look into how we approach those issues also. Any other members of the committee have questions for Senator Howe? Did you have your hand up earlier?
Not for Senator Porter, this testifier. I actually have a question for a previous testifier.
Thank you. Go ahead.
Mr. Hausladen.
Mr. Hausladen, come on up forward to the testifier table, please.
You know, as he's coming up, I've had to deal with a number of my constituents that have used CBD, and what they found is once they took the CBD, they lost their ability to drive truck, which was their livelihood. So I had to work through the federal waiver program to get these folks back into their behind the wheel and back to their livelihood. Mr. Hausladen, how does the legalization in Colorado affect the trucking industry's ability to hire drivers?
Mr. Chair, Senator Howell, thank
Mr.
you.
Hausladen.
Yes, I've been in contact with both the Colorado Motor Carriers Association and a Minnesota-based carrier that has operations in Minnesota and Colorado, and they say flat out their ability to recruit truck drivers has been dramatically hampered because they simply can't get people to pass the pre-employment drug tests, and I think that's an important point. As I said in my testimony, all DOT licensed and regulated industries, every mode of transportation must have pre-employment testing. And what we see happening is people who maybe are younger and they develop a cannabis lifestyle and have never thought that they want to be a pilot or an engineer or a truck driver and they want to, and now they apply and they just can't. They fail the test, they cannot become a truck driver. We have 8,000 truck driver shortage today. And as you all know, trucking is the lifeblood of the Minnesota's economy, and a supply chain is struggling. So I urge the committee to think about the long-term impacts of what this means in directly licensing of commercial truck drivers.
Follow up, Mr. Chair. So help me understand, is it, because with the CBD, it was a zero tolerance. Is that the same for cannabis, all cannabis use?
Mr. Hausladen.
Mr. Chairman, Senator Howe, that is correct. Per federal regulation, there's zero tolerance for a Schedule I drug like cannabis, regardless of how you take it in. And again, our industry has struggled with CBD because there's so many of these products that have been advertised as being CBD, not having THC, and lo and behold, they do. And so someone is taking it unwittingly, thinking they're buying a legal product, and then all of a sudden it's in their system, they pop positive, and now they've just lost their livelihood. And I think one of the things to be concerned about, this debate about the black market and the legitimate market, is the assumption that the black market will go away, as we already cited. The existence of the black market is an economic-driven factor, and it is driven by essentially inferior product, diluted, bad product, bad content. So to believe that people will not buy product on the black market and then have careers like truck driving not impacted is really not accurate. It will happen.
Any other members have any questions at this time? Senator Kroon.
Thank you, Mr. Chair. Of all the testimony I heard today, one thing really piqued my curiosity, and that is in the A2 amendment, subdivision 15, I heard that there's a proposal here to divert funds from the Trunk Highway Fund. Do you have any idea what dollar amount we're talking about here?
Senator Port.
Mr. Chair, Senator Kroon, thank you. The A2, we deleted all of the dollar amounts. I do not have a dollar amount to give you. We have estimates based on last year's, but the dollar amounts plus the locations that they will come from have not been finalized. So I cannot tell you, and I'm not willing to get into a hypothetical debate. We have not even finalized for sure that any will come from the Trunk Highway Fund.
Senator Kroon.
Thank you, Mr. Chair. I appreciate that answer. I'm just, it's a very sensitive subject for people in my district who have to live with Highway 65 every single day. And there's dire and urgent needs in our trunk highway system. I would hate to see any funds diverted from that fund to this endeavor. That's a comment. Mr. Chair, if I may have another question, please?
Yeah, Senator Kroon.
Thank you, Mr. Chair. For this question, I'll reference to page 80, lines 26 and 27. And it looks to me like the licensing for the existing medical cannabis licensees is going to expire under this bill. And I guess my question, what happens to the companies currently operating under the existing medical cannabis law? Will they be able to operate in the same manner? And if the answer to that is no, I guess my follow-up would be, why not?
Mr. Chair, Senator, the licensing, my
Go
apologies.
ahead, I just have to announce it for the record so people know who's speaking, so go ahead.
My apologies. The licensing provisions in this bill are among the most complex part of it, and they are in the process of quite a number of conversations about their revisions. So I anticipate that before it hits the committee that has jurisdiction over those licensing provisions, the bill may well look different than it does now, and we'll be able to get you specific answers to that.
If I may just add
Senator
to that, the intent is to ensure that the people who are currently in our medical cannabis, who are currently licensed to sell medical cannabis, are able to move into the new program. It is the fastest way, the most stable way, and the most responsive to our community members to slide them over. That is the intent.
Senator Kroon.
Thank you, Mr. Chair. I appreciate the intent, but the new requirements in the medical cannabis are significantly different than the requirements in the old one. And I would have very serious concerns. The providers, the existing providers, not being able to operate in the same manner that they're able to operate now. And so I think that's something we really need to take a hard look at as this bill moves forward, because there may be some deficiencies out there for some people who might like to look forward to this new medical cannabis system, but there are many that like the existing system, and there's a lot of jobs out there that are at stake, some in my district as well. So that's a concern of mine too. And then for my...
Go ahead, Senator Kroon.
Thank you, Mr. Chair. The other broad concern I have over this is the vast grant system here in the name of social equity. And I think I'll save a lot of these questions for later, the second time this comes around. But there's, I guess I don't know how many grant systems there are here. Seem to be various ones, and I'll just focus on the cannabis industry renewable grant for the sake of discussion, which is found on page 112. It seems to me to be a competitive grant process whereby taxpayer dollars will be given to a quote-unquote eligible organization, which in my reading could include for-profit businesses or quote-unquote community groups who want to make community investments in an eligible community, which means a community where social equity applicants reside. And then that is apparently where a disproportional impact of previous cannabis enforcement or something like that. I guess my question here is, what are community groups in that definition? I didn't see a definition for that. Could that just be a group of anybody?
Senator Port.
Thank you, Mr. Chair. I appreciate the question. You might be right, the community groups is not labeled in here.
I'd be happy to. Yes, Mr. Chair, Senator.
Ms. Fateh.
Thank you. This is comparable to other grant programs that are administered by DEED and other agencies where there is a process that DEED goes through to first select what the organization that would be receiving and then administering the grant would be. I think typically when I have seen this in other contexts, it has been nonprofit organizations, but they are subject to the auspices of deed, and there's an application process to become that entity that would then administer the grant. So you would need to demonstrate that you understand what the purpose of the grant program is, that you have the necessary infrastructure to be able to do it. Usually there are requirements for reporting back, and then if you don't, there are consequences to it. So I don't think the idea is for it to just be randomly distributed and then we hope for the best.
So members, we have about 7 minutes left to use the room, and I've got 3 more members who want to ask questions. So Senator Kroon.
Thank you, Mr. Chair. I've got many more questions, but I'll limit it to one final question here so other members can have an opportunity to ask questions. I'm searching in this grant process for some measure of accountability. We all know that there's been waste, fraud, and abuse lately in the news, and I'm looking to prevent that in this system. And all I can really find, and I'm hoping maybe you can direct me to somewhere where I'm missing, is for this one, let's say page 113, lines 6 through 10, which basically requires this new agency that's going to be created to send a list of awards given through this program to committee chairs and ranking members, minority members. Are there any other safeguards in place in this bill to prevent waste, fraud, and abuse of taxpayer dollars in these newly formed grant programs?
Senator Port.
Thank you, Chair Latz and Senator Kroon. First, to your last point on the community group definition, would be happy to work with you to figure out that language in a way that works most effectively. There are accountability measures in here. They are in, I believe, the miscellaneous section. And more formally in the studies section, where there are specific studies that are required to be provided back each year regarding the programs and the grants that have gone out, who has qualified for them, how effective they have been, and tracking every dollar, essentially. So there is a piece in there. I would be happy to meet with you offline to discuss it further, but I appreciate your concern on this. It is something we wanted to be very clear about because this will be a significant investment, and we want to make sure that it is actually going to the communities that we are trying to target with these kinds of grants, and that it is used effectively in the way it's supposed to.
Senator Carlson.
Thank you, Mr. Chair. Mr. Chair, and I believe Ms. Leahy or Senator Port, I have 3 questions. I'm going to ask them all at the same time, and you can pick which ones you'd like to answer, if any. One is I'd like to know what the plan is for child safety containers. Is that something that is just a typical type of container, like for a drug? And also, I'd like to know if there's any hope for field testing that can determine the level of perhaps even influence that a person is under when they get stopped. And also, what is the nature of employer being able to prohibit the use for those positions that may be safety related, something like that, warehouse worker or something like that? Thanks, Vice Chair.
Mr. Chair, Senator Carlson, I'd be happy to answer all 3 of those. So when it comes to the child safety containers, the bill defines it requires child-resistant packaging, and what child-resistant packaging is pegged to the regulations in the federal code. So the same ones that the FDA and others, utilize. And then when it comes to the field testing, the bill has a provision, I think it's Article 4, Section 16, that includes funding for a pilot for an oral test. Certainly can't be used for the purposes of prosecution of somebody that has been driving impaired, that would be, based on the field test as it is for everything but alcohol. But because we know that this is an issue and a technology that people would like to see, it does include some funding so that we can begin to do some pilots of what that technology might be, because there are some promising ones that have been developed. And as for what an employer can do, so the bill basically brings cannabis and the way it's handled kind of into compliance with the way it is handled with alcohol, but then some additional measures on top of that. So, the same way under Minnesota law, an adult can responsibly use an adult use product on their personal time. If it doesn't have a nexus to their ability to do their job, that's fine, and the employer can't go after it. But if the position has a nexus to safety, so if you're a school bus driver, a bus driver, there are a bunch of different childcare worker, there are provisions in there that do allow the employer to prohibit your use. In those instances, of course, you can always be prohibited from being under the influence while doing your job. And then when it comes to things like, for example, federally, professions that have federal regulations on them, like the DOT licensing and things like that, those are within the jurisdiction of the federal government. The state is not going to curtail those.
Thank you.
All right.
One additional.
I got two more people
Yes,
want to
no.
ask questions, Senator Carlson.
Allow random testing?
Senator Port.
I'm sorry, can you repeat the question?
Does it allow random testing?
Senator Port.
Thank you. Thank you, Chair Latz and Senator Carlson. It does not allow for random testing if you are not in one of those specific safety groups. So if just like we can't test you for alcohol, if you go into your job for no reason. If there is a level of impairment, perceived, then I think there are provisions that allow for it then, but not just random testing.
Thank you.
Senator Limmer.
Thank you, Mr. Chairman. I don't know if we have enough time to go through a number of questions I might have.
Probably not, but keep in mind this bill will come back to us.
Right.
And when it comes back, we'll focus on our own jurisdiction and not
Right.
some of the broader questions that we've all raised that are.
This has been useful, Mr. Chairman, this hearing. My number one concern is the safety of our citizens. And placing a drug into the legal category for use, which has impairment, without the quality of determining intoxication, I don't know why we would do that. We've heard testimony today of a son being lost. We have record in other states that have gone down this path of increased traffic accidents, accidents with heavy equipment. There's all sorts of places. We've had police chiefs in previous committees ask, what if my officer on his day off uses the then legal substance on a Sunday afternoon, and he has to be required to be at work at 11 o'clock that very night and put a gun on his hip and then make judgment of whether or not to use that gun or not. We've heard about the cost of dogs that are trained to point at marijuana and other illicit drugs, and now all those dogs will have to be dismissed, and at $40,000 a piece in training, that's going to be a hit to the budget. So I have a long way to go before I accept this bill. But nevertheless, I'll hold my questions, Mr. Chairman. And I'd like to have perhaps a broader perspective from law enforcement on what they see in the future based on other states and what they've had to deal with. So thank you, Mr. Chairman. I'll hold my questions.
Senator Howe, final question? Already answered?
No time.
Some other day?
We'll hold our questions. I'll get a shot at this tomorrow, too.
Thank you, Senator Howe. Don't aim too accurately. All right, right. The bill is now going to move to the Commerce Committee, and then it's going to be heard in many other committees along the way in the Senate, and will come back to us for more robust discussion, more focused on what's within our jurisdiction. So if you're on the other committees, when you see it, go ahead and be sure to try to get some of your questions answered then as well. At this point, I'm going to recognize Senator Pappas for a motion.
Thank you, Mr. Chairman, and thank you for the Senator Port for the excellent presentation, and thank you to all the witnesses that took the time to come here and share with us your experiences and your perspectives. I would like to move that Senate File Number 73 as amended be passed with no recommendation and be re-referred to the Commerce Committee.
Senator Pappas has made the motion. All those in favor say aye. Aye. Opposed? Motion prevails. There being nothing further before the committee at this time, we are adjourned. Thank you, members.
Thank you, Mr. Chair.
Senator Diesig.
Mr. President, I move that further proceedings on the roll call be